Hello friends, welcome to Premier UPSC Ias. Continuing with the polity lectures uh, pertaining to prelims examination, today we are going to cover Supreme Court, High Courts and subordinate courts. Okay, Indian judicial system. The Indian Constitution has established an integrated judicial system with Supreme Court at the top and the High Courts below it. There is a hierarchy of subordinate courts under a High Court, like district courts, session courts, and other lower courts. This single system of courts was adopted from the Government of India Act 1935. This system enforces both central laws as well as the state laws. However, in the USA, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. Integrated judicial system. 1. Supreme Court, apex judicial body like a federal court, final interpreter and guardian of the Constitution, highest court of appeal, guarantor of the fundamental rights. High courts at state level and high courts at the district level and session courts, district courts, etc. The Union Judiciary, Article 124 to 147, Part 5 of the Indian Constitution, the Indian Union. The High Courts, Article 214 to 232, subordinate courts from Article 233 to 237, Part 6, the states. Supreme Court. Introduction. Supreme Court succeeded the Federal Court of India, established under the Government of India Act 1935. The Supreme Court of India was inaugurated on January 28, 1950. The jurisdiction of the Supreme Court is greater than that of its predecessor because it has replaced the British Privy Council as the highest court of appeal. The Supreme Court of India has more power than any other Supreme Court in any part of the world. Article 124, Establishment and Constitution of Supreme Court. Article 125, Salaries of Judges. Article 126, Appointment of Acting Chief Justice. Article 127, Appointment of Ad hoc Judges. Article 128, Attendance of retired judges at sittings of the Supreme Court. Article 129, Supreme Court to be a court of record. Article 130, Seat of Supreme Court. 131, Original jurisdiction of the Supreme Court. 132, Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. Article 133, Appellate jurisdiction of Supreme Court in appeals from the high courts in regard to civil matters. 134, Appellate jurisdiction of Supreme Court in regard to criminal matters. Article 134A, Certificate for appeal to the Supreme Court. Article 135, Jurisdiction and powers of the Federal Court under existing law to be exercisable by the Supreme Court. 136, Special leave to appeal by the Supreme Court. 137, Review of judgments or orders by the Supreme Court. 138, Enlargement of the jurisdiction of the Supreme Court. 139, Conferment on the Supreme Court of powers to issue certain writs. 139A, Transfer of certain cases. 140, Ancillary powers of Supreme Courts. 141, Law declared by Supreme Court to be binding on all courts. 144, 142, Enforcement of decrees and orders of Supreme Court and orders as to discovery, etc. 143, Power of the President to consult Supreme Court. 144, Civil and judicial authorities to act in aid of the Supreme Court. 145, Rules of Court, etc. 146, Officers and servants and the expenses of the Supreme Court. 147, Interpretation. Constitution of Supreme Courts. Article 124. There shall be a Supreme Court of India consisting of a Chief Justice of India and not more than 7 other judges. The Parliament by law can prescribe a large number of judges in Supreme Court. Originally, the strength of the Supreme Court was fixed at 8. The Parliament has increased this number of other judges progressively. At present, the Supreme Court consists of 31 judges, and as of now, it's more than 31, 35, and 6. It has been in recent news also. Appointments of judges. Article 124. The judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts as he deems necessary. The judges are appointed by the President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than the Chief Justice. What does mean by consultation with Chief Justice of India? The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But in the second judge's case 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court. But the Chief Justice would tender his advice on the matter after consulting two of his senior-most colleagues. Similarly, in the third judge's case 1998, the court opined that a consultation process to be adopted by the Chief Justice of India required consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of four senior-most judges of the Supreme Court, and if two judges give an adverse opinion, he should not send the recommendation to the government. Moreover, the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. Constitution 99th Amendment Act 2014 Article 124A, B and C struck down by Supreme Court in 2015. Attempt by legislature to replace the collegiate system. The 99th Constitutional Amendment Act of 2014 and the NJAC Act of 2014 have replaced the collegiate system of appointing judges to the Supreme Court and High Courts with a new body called National Judicial Appointments Commission. In order to this, three new articles 124A, B, and C were inserted in the Constitution. In the fourth judges case 2015, the Supreme Court delivered the verdict that the new system would affect the independence of the judiciary. Hence, amendment has been struck down by the Supreme Court's order dated 16 October 2015 in the Supreme Court Advocates on Record Association versus Union of India. Subsequently, in 2015, the Supreme Court has declared both the amendment as well as the NJAT Act as unconstitutional and void. Consequently, the earlier collegiate system became operative again. National Judicial Appointment Commission, Article 124A. There shall be a commission to be known as the NGAC consisting of the following name. But this was struck down by the Supreme Court, it is not that much important. Qualifications of the judges, Article 124. A person to be appointed as a judge of the Supreme Court should have the following qualifications. He should be a citizen of India. He should have been a judge of a high court or high courts in succession for 5 years, or he should have been an advocate of a high court or a high court in succession for 10 years, or he should be distinguished jurist in the opinion of the president. Oath or affirmation, Article 124. A person appointed as a judge of the Supreme Court has to make and subscribe an oath or affirmation before the President and some person appointed by him for this purpose, such as to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully and to the best of his ability, knowledge, and judgment perform the duties of the office without fear or favor, affection, or ill will, and to uphold the Constitution and the laws. Tenure of the judges, Article 124. The Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Similarly, it has not fixed the tenure of a judge of the Supreme Court. However, it makes the following three provisions in this regard. He holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by the Parliament. He can resign his office by writing to the President. Removal of judge, Article 124. A judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each house of the Parliament. The grounds of removal are two: proved misbehavior or incapacity, but these are not defined in the Constitution. Process of removal of judges. The Judges Enquiry Act 1968 regulates the procedure relating to the removal of a judge of the Supreme Court and High Court by the process of impeachment. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha is to be given to the Speaker or Chairman. The Speaker or Chairman may admit the motion or refuse to admit it. If it is admitted, then the Speaker or Chairman is to constitute a three-member committee to investigate into the charges. The committee should consist of the Chief Justice or the Judge of a Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Finally, the President passes an order removing the judge. Judges against whom process of impeachment was initiated. Justice V. Ramaswamy. So, judges against whom the process of the impeachment was initiated. The first one here is Justice V. Ramaswamy, 1993. He was the first judge against whom impeachment was proceedings were initiated in 1993. The motion was brought up in Lok Sabha, but it failed to secure the required two-thirds majority. Justice Ramaswamy was caught in a controversy for spending extravagantly on his official residence during his tenure as Chief Justice of Punjab and Haryana during 1990. Soumitra Sen, 2011. Justice Soumitra Sen of the Calcutta High Court in 2011 avoided the ignominy of becoming the first judge to be impeached by Parliament by tendering his resignation. He did so after the Rajya Sabha had passed the motion making him the first judge to have been impeached by the upper house for misconduct. Justice Sen was found guilty of misappropriating over rupees 33.23 lakh under his custody as a court-appointed receiver in the capacity as a lawyer and misrepresenting the facts before a Calcutta court in a 1983 case. P.D. Dinakaran, 2011. Rajya Sabha chairman had set up a judicial panel to look into allegations of corruption against Justice P.D. Dinakaran, but he resigned in July 2011 before impeachment proceedings could be initiated against him. He was the Chief Justice of the Sikkim High Court. J.B. Pardiwala, 2015. In 2015, a group of 58 Rajya Sabha MPs moved an impeachment notice against Justice J.B. Pardiwala of the Gujarat High Court for his objectionable remarks on issue of reservation. The specific objections seem to be connected to the observations made by the judge in his one of the judgments. Hours after the impeachment notice was sent to the president, the judge removed the wording from his judgment. Salaries and allowances of judges. Article 125. The salaries, allowances, privileges, leave, and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. Appointment of Acting Chief Justice of India. Article 126. The President can appoint a judge of the Supreme Court as an Acting Chief Justice of India when the office of the Chief Justice of India is vacant, or the Chief Justice of India is temporarily absent, or the Chief Justice of India is unable to perform the duties of his office. Ad hoc judges. Article 127. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. The judge so appointed should be qualified for appointment as a judge of the Supreme Court. Appointment of retired judges. Article 128. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court to act as a judge of the Supreme Court for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers and privileges of a judge of Supreme Court, but will not otherwise be deemed to be a judge of Supreme Court. Seat of Supreme Court. Article 130. The Constitution declares that Delhi as a seat of the Supreme Court, but it also authorizes the Chief Justice of India to appoint other places or places as seat of the Supreme Court. He can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or the Chief Justice to appoint any other place as a seat of the Supreme Court. Procedure or rules of courts. Article 145. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143, power of the President to consult Supreme Court, are decided by a bench consisting of at least 5 judges. All other cases are usually decided by a bench consisting of not less than 3 judges. The judgments are delivered by the open court. All judgments are by majority vote, but in differing, then judges can give dissenting judgments or opinions. Jurisdictions and the power of the Supreme Court. Original jurisdiction, writ jurisdiction, appellate jurisdiction, advisory jurisdiction, a court of record, power of judicial review, other powers. Original jurisdiction, Article 131. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation. More elaborately, any dispute between the center and one or more states, or the center and any state or states on one side and one or more states on the other, or between two or more states. In these disputes, the Supreme Court has exclusive original jurisdiction, exception of the Supreme Court jurisdiction. Further, this jurisdiction of the Supreme Court does not extend to the following: a dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sanad, or other similar instrument, a dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. Interstate water disputes. Matters refer to the Finance Commission, adjustment of certain expenses and pensions between the center and the states, ordinary dispute of commercial nature between the center and the states, recovery of damages by a state against the center. Writ jurisdiction, Article 139 and 139A. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction. The High Courts are also empowered to issue writs. Appellate jurisdiction. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under 4 heads: appeals in constitutional matters, appeal in civil matters, appeals in criminal matters, and appeals by special leave. Article 132. Appellate jurisdiction of the Supreme Court in appeals from the High Court in certain cases. In the constitutional cases, an appeal can be made to the Supreme Court against the judgment of a High Court. It can be made only if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on a certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. Article 133. Appellate jurisdiction of Supreme Court in appeals from High Courts in regard to civil matters. In civil cases, an appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies that the case involves a substantial question of law of general importance and that the question needs to be decided by the Supreme Court. Article 134. Appellate jurisdiction of Supreme Court in regard to criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceeding of a High Court if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to death, or certifies that the case is a fit one for appeal to the Supreme Court. Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment. The final order or sentence in a criminal proceeding of a High Court in the territory of India, subject to such conditions and limitations as may be specified in such law. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court for the first 2 clauses of the Article 134. Accordingly, appeal can also be made for convicted the accused person and sentenced him to imprisonment for life or for 10 years. Article 134A. certificate for appeal to the Supreme Court. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country, except military tribunal and court martial. This provision contains the four aspects as under it is a discretionary power and hence cannot be claimed as a matter of right. It can be granted in any judgment, whether final or interlocutory. It may be related to any matter, constitutional, civil, criminal, income tax, labor, revenue, advocate, etc. It can be granted against any court or tribunal and not necessarily against a high court of courts, except a military court. Thus, the scope of this provision is very wide and it vests the Supreme Court with a plenary jurisdiction to hear appeals. Advisory jurisdiction. Article 143. The Constitution authorizes the President to seek the opinion of the Supreme Court in the two categories of matters on any question of law or fact of public importance which has arisen or which is likely to arise, on any dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, sanad or other similar instruments. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not binding on the President. He may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. A court of record. Article 129. As a court of record, the Supreme Court has two powers. The judgments, proceeding, and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. It has power to punish for contempt of court either with simple imprisonment for a term up to 6 months or with fine of up to 2,000 or with both. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of high courts, subordinate courts, and tribunals functioning in the entire country. What is contempt of court? The expression contempt of court has not been defined by the Constitution. However, the expression has been defined by the Contempt of Court Act of 1971. Contempt of court may be civil or criminal. Civil contempt. It means willful disobedience to any judgment, order, writ, or other process of a court, or willful breach of an undertaking even given to a court. Criminal contempt. It means the publication of any matter or doing an act which scandalizes or lowers the authority of a court or prejudices or interferes with the due course of a judicial proceeding or interferes or obstructs the administration of justice in any other manner. Power of judicial review. Article 137. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and executive orders of both the central and the state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, null and void by the Supreme Court. Consequently, they cannot be enforced by the government. Doctrine of Judicial Review. The doctrine of judicial review originated and developed in the USA. In India, the Constitution itself confers the power of judicial review on the judiciary, both the Supreme Court as well as high courts. Further, the Supreme Court has declared the power of judicial review as a basic feature of the Constitution or an element of the basic structure of the Constitution. Hence, the power of judicial review cannot be curtailed or excluded even by a constitutional amendment. The judicial review can be classified into the following three categories: judicial review of the constitutional amendments, judicial review of legislation of the parliament and state legislatures and subordinate legislations, judicial review of administrative action of the union and state and authorities under the state. In 2015, the Supreme Court declared both 99th Constitutional Amendment 2000 and 2014 and National Judicial Appointments Commission NJAC Act 2014 as unconstitutional and null and void. Why is judicial review needed? In the Indian democratic system, judicial review is needed for the following reasons: to uphold the principle of supremacy of the Constitution, to maintain the federal equilibrium that is in the balance between the center and the states, to protect the fundamental rights of the citizens. constitutional provisions for judicial review. Though the phrase judicial review has nowhere been used in the Constitution, however, the provisions of several articles explicitly confer the power of judicial review on the Supreme Court and the High Courts. These provisions are explained below. Article 13. All laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. 32. Guarantees the right to move the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue directions on orders or writs for that purpose. Article 131 provides for the original jurisdiction of the Supreme Court in center, state, and interstate disputes. Article 132 provides for the appellate jurisdiction of the Supreme Court in constitutional cases. Article 133 provides for the appellate jurisdiction of the Supreme Court in civil cases. Article 134 provides for the appellate jurisdiction of the Supreme Court in criminal cases. Article 134A provides for the certificate for appeal to the Supreme Court from the High Courts. Article 135 empowers the Supreme Court to exercise the jurisdiction and powers of the federal court under any pre-constitution law. Article 136 authorizes the Supreme Court to grant special leave to appeal from any court or tribunal except military tribunal and court martial. Article 143 authorizes the President to seek the opinion of the Supreme Court on any question of law or fact and on any pre-constitutional legal matters. Article 226 empowers the High Courts to issue directions or orders or writs for the enforcement of the fundamental rights and for any other purpose. Article 227 vests in the High Courts the power of superintendents over all courts and tribunals within their respective territory jurisdictions, except military courts or tribunals. Article 245 deals with the territorial extent of laws made by Parliament and by the legislatures of state. Article 256 deals with the subject matter of laws made by Parliament and by legislatures of states, that is, Union list, state list, and concurrent list. Article 251 and 254 provide that in case of a conflict between the central law and state law, the central law prevails over the state law and the state law shall be void. Article 327 deals with the continuance in force of the pre-constitutional laws. Scope of the judicial review. The constitutional validity of a legislative enactment or an executive order can be challenged in a Supreme Court or in the High Court on the following three grounds. It infringes the fundamental rights, part 3. It is outside the competence of the authority which has framed it, and it is repugnant to the constitutional provisions. Judicial activism. Like the judicial review, the concept of judicial activism originated and developed in the USA. In India, the doctrine of the judicial activism was introduced in mid-1970s when the following judges laid the foundations of judicial activism in the country: Justice V.R. Krishna Iyer, Justice P.N. Bhagavati, Justice O. Chinnappa Reddy, and Justice D.A. Desai. Judicial activism denotes the proactive role played by the judiciary in the protection of the rights of citizens and in the promotion of justice in a society. In other words, it implies the assertive role played by the judiciary to force the other two organs of the government, legislature and executive, to discharge their constitutional duties. Judicial activism is also known as judicial dynamism. It is the antithesis of judicial restraint, which means the self-control exercised by the judiciary. Trends reflecting the judicial activism: expansion of rights of hearing in administrative processes, excessive delegation without limitation, expansion of judicial control over discretionary powers, expansion of judicial review over the administration, promotion of open government, indiscriminate exercise of contempt power, exercise of jurisdiction when none exists, and overextending the standard rules of interpretation in its research to achieve economic, social, and educational objectives, and so on. Public interest litigation (PIL). The concept of judicial activism is closely related to the concept of public interest litigation (PIL). It is the judicial activism of the Supreme Court which is the major factor for the rise of PIL. In fact, PIL is the most popular form of manifestation of judicial activism. In the USA, it was designed to provide legal representation to previously unrepresented groups and interests. In India, the PIL is a product of judicial activism role of the Supreme Court. Justice V.R. Krishna Iyer and Justice P.N. Bhagavati were the pioneers of the concept of PIL. PIL is also known variously as social action litigation, social interest litigation, and class action litigation. Under the PIL, any public spirited citizen or a social organization can move the court for the enforcement of the rights of any person or group of persons because they are unable to approach the court for the remedies due to their poverty or ignorance or socially or economically disadvantaged position. The Supreme Court has defined the PIL as a legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of the community have pecuniary interest or some interest by which their legal rights or liabilities are affected. Other powers. It has original, exclusive, and final authority to the disputes regarding the election of the president and the vice president. In this regard, it has the it inquires into the conduct and behavior of the chairman and members of the UPSC on a reference made by the president. It has power to review its own judgment or order, thus it is not bound by its previous decision and can depart from it in the interest of justice or community welfare. In brief, the Supreme Court is a self-correcting agency. It is authorized to withdraw the cases pending before the High Courts and dispose them by itself. It can also transfer a case or appeal pending before one High Court to another High Court. Its law is binding on all courts in India. It is the ultimate interpreter of the Constitution. It has power of judicial superintendence and control over all the courts and tribunals. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. Indian Supreme Court versus American Supreme Court. Original jurisdiction confined to federal cases, whereas in America covers not only the federal cases but also cases relating to naval forces, maritime activities, ambassadors, etc. Appellate jurisdiction. Indian Supreme Court covers the constitutional, civil, and criminal cases, whereas American Supreme Court confined to the constitutional cases only. Special leave to appeal. Very wide discretion to grant in any matter against the judgment of any court or tribunal except military in Indian Supreme Court, whereas in American Supreme Court, no such plenary power. High courts. Evolution of High Court in India. In the Indian single integrated judicial system, the High Court operates below the Supreme Court but above the subordinate courts. The judiciary is in a state consists of a High Court and a hierarchy of subordinate courts. The institution of High Court originated in India in 1862 when the High Courts were set up at Calcutta, Bombay, and Madras. In 1866, a fourth High Court was established at Allahabad. The Constitution of India provides for a High Court for each state, but the Seventh Amendment Act of 1956 authorized the Parliament to establish a common High Court for two or more states or for two or more states and a union territory. The territorial jurisdiction of a High Court is coterminous with the territory of a state. New and common high courts in India. At present, there are 25 high courts in the country. Following high courts are the newest high courts established in the last decade: Manipur 2013, Meghalaya 2013, Tripura 2013, Telangana 2019. Delhi is the only union territory that has a high court of its own since 1966. Out of them, following are the common high courts. Bombay. Bombay High Court is common for Maharashtra, Goa, Dadar, and Nagar Haveli and Daman and Diu. Calcutta, West Bengal, Andaman and Nicobar Islands. Guwahati, Assam, Nagaland, Mizoram, and Arunachal Pradesh. Kerala and Lakshadweep. Madras, Tamil Nadu and Puducherry. Punjab, Haryana, and Chandigarh. Article 214, High Court for States. Article 215, High Courts to be courts of record. Article 216, Constitution of High Courts. Article 217, Appointment and conditions of the office of a judge of a High Court. Article 218, Application of certain provisions related to Supreme Court to High Courts. Article 219, Oath or affirmation by judges of the High Courts. Article 220, Restriction on practice after being a permanent judge. Article 221, Salaries of the judges. 222, Transfer of a judge from one court to another. 223, Appointment of active Chief Justice. 224, Appointment of additional and acting judges. 224A, Appointment of retired judges at sittings of high courts. 225, Jurisdiction of existing high courts. 226, Power of the high courts to issue certain writs. 227, Power of the superintendents over all courts by the High Court. 228, Transfer of certain cases to High Court. 229, Officers and servants and expenses of High Courts. 230. Extension of the jurisdiction of high courts to union territories. 231. Establishment of a common high court for two or more states. 241. High courts for union territories. Constitution of High Court. Article 216. Every High Court, whether exclusive or common, consists of a Chief Justice and such other judges as the President may from time to time deem necessary to appoint. Thus, the Constitution does not specify the strength of a High Court and leaves it to the discretion of the President. Accordingly, the President determines the strength of a High Court from time to time depending upon its workload. Appointment of judges. Article 217. The judges of a high court are appointed by the president. The chief justice is appointed by the president after consultation of the chief justice of India and the governor of the state concerned. For appointment of other judges, the chief justice of the concerned high court is also consulted. In case of a common high court for two or more states, the governors of all the states concerned are consulted by the president. Qualification. Article 217. Citizen of India held a judicial office in the territory of India for 10 years, or he should have been an advocate of a high court or high court succession for 10 years. Subordinate courts. Article 233. Appointment of district judges. 233A. Validation of appointments of and judgments, etc., delivered by certain district judges. 234. A recruitment of persons other than district judges to the judicial service. 235. Control over subordinate courts. 36. Interpretation. 237. Application of the provisions of this chapter to certain class or classes of magistrates. Appointment of district judge. Article 233. The appointment, posting, and promotion of the district judges in a state are made by the governor of the state in consultation with the High Court. A person to be appointed as a district judge should have the following qualification: already be in a service of the central or the state government, an advocate or a pleader for 7 years, recommended by the High Court for appointments. Appointment of other judges. Article 234. Appointment of persons other than district judges to the judicial service of a state are made by the governor of the state after consultation with State Public Service Commission and the High Court. Control over subordinate courts. Article 235. The control over the district courts and other subordinate courts, including the posting and promotion and leave of the persons belonging to the judicial service of a state and holding any post inferior to the post of district judge, is vested in the High Court. Structure and jurisdiction. The original structure, jurisdiction, and nomenclature of the subordinate judiciary are laid down by the states, hence, they differ slightly from state to state. Generally, there are three tiers of civil and criminal courts below the High Court. This is classified as the following: district or session courts, subordinate courts, municipal or magistrate courts. High Court, district or session judges courts, civil and criminal two parts. In civil, subordinate judge court and municipal court. In criminal, chief judicial magistrates court and judicial magistrate court. District court, subordinate courts, court of municipal judicial magistrates.